Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from the UPSC Civil Services examination point of view. Today let us take up the New Delhi edition of the Hindu newspaper dated 14 June 2022. The news to be taken up has been displayed on your screen and timestamping for these has been provided in the YouTube description. So on this note, let's start our today's discussion from the prelims and mains point of view. Let's take up the first news appearing on page number 3. Now this news says Anil Deshmukh moves High Court seeking release for 1 day. And in his petition, he has sought release for 1 day so that he can vote in the upcoming State Legislative Council elections in Maharashtra, which is on 20th of June. Now, earlier also, Anil Deshmukh had filed a petition before the Enforcement Directorate, and the Enforcement Directorate had opposed the release of Mr. Deshmukh even for a day to cast his vote in the Rajya Sabha election. So in this news analysis, let us understand whether prisoners and under trial prisoners can vote in an election or not. Now this particular question, as you can see, was asked by UPSC in the 2017 prelims examination. And this question was, right to vote and to be elected in India is a, options were A, fundamental right, B, natural right, C, constitutional right, and D, legal right. Now this newspaper mentions the fact that right to vote is a statutory right under section 62 of the Representation of People Act 1951. However, this right which has been provided under section 62 of Representation of People Act 1951 flows from article 326 of the Indian Constitution, which specifically says that elections to the House of People and Legislative Assembly of every state shall be on the basis of adult suffrage, which means every person who is a citizen of India and who is not less than 18 years of age on such date fixed by the Election Commission shall be entitled to vote. However, this article also prescribes for certain disqualification also. So it says that a person shall not vote if they are disqualified under this constitution or any law made by appropriate legislature on the ground of non-residence, unsoundness of mind, crime, or corrupt or illegal practice. So these grounds can become a ground for disqualification for voting purposes. Now, section 62 of the Representation of People Act provides for right to vote. Now, this right, as I have mentioned, flows from article 326. And hence, according to UPSC answer key, the correct answer to this question was constitutional right and not legal right. Now talking about right to vote, let's also go through article 327 of the Indian Constitution. Now this article says that Parliament has power to make provisions with respect to elections to legislature. So it says that subject to the provision of this Constitution, Parliament may from time to time by law make provisions with respect to all matters relating to or in connection with elections to either House of Parliament or either House of the State Legislature, including preparation of electoral rolls, delimitation of constituencies, and all other matters necessary to secure due constitution of such house or houses. So basically, Parliament may by law regulate the conduct of elections, including preparation of electoral rolls, delimitation of constituencies, and all other matters necessary to conduct the election. And based on these provisions, the Parliament enacted Representation of People Act 1951 and also Representation of People Act 1950. Now talking about right to vote under section 62 of Representation of People Act 1951. Now this provision says that every person whose name is registered in the electoral roll of any constituency shall be entitled to vote in that constituency. And if a person's name is not registered in the electoral roll, then such person shall not be entitled to vote. It further says that no person shall vote at an election in any constituency if he is subject to any of the disqualifications referred in Section 16 of Representation of People Act 1950. So here, let's go through the provisions of Section 16 of RPA 1950. Now this provision mentions about disqualification for registration in electoral roll. So it says that a person shall be disqualified for registration in an electoral roll. That is, a person's name shall not be registered in the electoral roll if he is not a citizen of India, or if such person is of unsound mind and is accordingly declared by a competent court, or for the time being is disqualified from voting under the provisions of any law relating to corrupt practices and other offences in connections with elections. Now these offences has been provided in the Representation of People Act 1951. The provision further says that if any person has become disqualified on any of these grounds, then their name shall be struck off from the electoral roll. Now further, this provision highlights that if disqualification of a person has been removed by law, then such person's name shall be reinstated in the electoral roll. So if a person's disqualification has been removed, then their name shall be reinstated in the electoral roll. So these are the grounds of disqualifications under Section 16 of Representation of People Act 1950. Now coming back to Section 62 of RPA 1951, it further says that no person shall vote at a general election in more than one constituency of the same class, and if a person votes in more than one such constituency, his votes in all such constituencies shall be void. So suppose, for example, name of a person appears in two constituencies, constituency A and constituency B, and he goes on to vote in both the constituencies. So in such instances, his vote in both the constituencies shall be declared as void. And similar provision has been provided under Section 62 Clause 4. It says that no person shall at any election vote in the same constituency more than once. And if we do so, then all his votes in that constituency shall be void. Now there have been lot of debates around Section 62 Clause 5 with respect to right to vote for prisoners and also for under trials. So in this regard, let's understand the provision of Section 62 Clause 5, which says that no person shall vote at any election if he is confined in prison, whether under a sentence of imprisonment or transportation or otherwise, or is in the lawful custody of the police. So if a person is confined in prison, if he is undergoing a sentence of imprisonment, or he is in police custody, so in all these cases, these people will not have the right to vote. However, Section 62 Clause 5 will not apply to any person who is convicted or who is subjected to preventive detention under any law of India. So Section 62 Clause 5 becomes very important for us to understand, especially with respect to rights of prisoners and under trials. Now the Model Prison Manual 2016, published by Ministry of Home Affairs, defines the terms prisoner, convict and under trial prisoner. So prisoner means any person confined in prison under the order of competent authority or in court. Now convict means any prisoner under sentence of a court exercising criminal jurisdiction or court martial, and includes a person detained in prison according to Chapter 8 of CRPC, which deals with security for keeping the peace and for good behavior, and according to Prisoners Act. According to Prisoners Act, criminal prisoner means any person duly committed to custody under the writ, warrant or order of any court or authority exercising criminal jurisdiction or by order of court martial. And under trial prisoners include a person who has been committed to judicial custody pending investigation or trial by a competent authority. So Supreme Court in number of decisions have stated that as per Section 62 Clause 5 of Representation of People Act 1951, it basically disqualifies any person who is confined in a prison no matter the reason, and also disqualifies any person in police custody also. So this means that convicted prisoners, under trial prisoners and any person in police custody does not have the right to vote as long as the person is in such imprisonment or such custody. Now to understand the reasons as to why prisoners and also under trial prisoners are not provided right to vote, let's go through the important highlights of the Supreme Court judgment of Anukul Chandra Pradhan, Advocate Supreme Court versus Union of India. Now, in this judgment, the Supreme Court provided various reasons for the validity of Section 62 of Representation of People Act 1951, which provides for right to vote and which also provides for certain disqualification with respect to right to vote. Now, further, the Supreme Court also equated Article 14 and stated that it is a settled principle that Article 14 permits reasonable classification. And here the reasonable classification is between people who are undergoing any trial or who are undergoing any prison and with those people who are free. So the Supreme Court says that Article 14 permits reasonable classification which has a rational nexus with the object of classification. And this provision made in the election law, excluding persons with a criminal background, was to further the objective of preventing criminalization of politics and maintaining probity in elections. So one of the main reasons as to why the undertrials and also the prisoners are not allowed to vote in election is to prevent criminalization of politics and also to ensure that elections are conducted in a peaceful manner. So one of the main reasons given by Supreme Court of disallowing either under trial prisoners or even prisoners from right to vote is to prevent criminalization of politics. As according to the court, criminalization of politics impacts free and fair election, which is a basic feature of the Indian Constitution. The Supreme Court further stated that if prisoners are allowed to vote, then there would be need for extra security, and this would result in resource crunch. So the Supreme Court stated that to conduct free, fair and orderly election, there is a need to deploy considerable amount of police force, and permitting every person in prison also to vote would require deployment of a much larger police force and much greater security arrangements in the conduct of election. And it will be difficult for the government to ensure more security, especially for prisoners while voting. So the court stated that apart from resource crunch, the other constraints relating to availability of more police force and infrastructure facilities are traditional factors to justify restrictions imposed by Section 62 Clause 5. Now, another very important aspect highlighted by the Supreme Court is regarding deprivation of liberty for prisoners. So the court stated that a person who is in prison as a result of his own misconduct is therefore deprived of his own liberty during the period of his imprisonment and cannot claim equal freedom of movement, speech and expression with others who are not in prison. So basically, by applying Article 14, the court distinguished between those people who by their own misconduct are either undergoing criminal trial or are in prison, and those group of people who are free, that is, who have not done any criminal activity. And accordingly, the court stated that by disqualifying or prohibiting such class of people from voting does not violate Article 14, as it is a reasonable classification having a rational nexus. So the court stated that the classification of person in and out of prison separately is reasonable. Moreover, if the object is to keep persons with criminal background away from election scene, a provision imposing a restriction on prisoner to vote cannot be called unreasonable. So these are the reasons which have been provided by Supreme Court of India in this particular case, and these reasons have been stated again and again in various judgments. Now, coming back to this question asked by UPSC in 2017, there was a lot of controversy whether the answer would be constitutional right or legal right, as this news also highlights that right to vote is a statutory right under Section 62 of RPA 1951. Now, these confusions have been created because of different judicial decisions. Now, in Ramakant Pandey versus Union of India, which also referred Jyoti Basu versus Debi Ghoshal, stated that right to elect, fundamental though it is to a democracy, is neither a fundamental right nor a common law right. It is pure and simple a statutory right. And this judgment was given in 1993. However, in the judgment of PUCL versus Union of India given in 2003, Justice Reddy in its judgment stated that right to vote for candidate is of one's choice is of the essence of democratic polity. And this right is recognized by our Constitution and it is given effect to in specific form by Representation of People Act. Now, right to vote, if not a fundamental right, is certainly a constitutional right. The right originates from the Constitution and in accordance with the constitutional mandate contained in Article 326 of the Indian Constitution. And this right has been shaped by the statute, namely the Representation of People Act. So Justice Reddy stated that it is not very accurate to describe it as a statutory right, pure and simple. So we see that there have been conflicting decisions with respect to right to vote, whether being a statutory right or whether it is a constitutional right under Article 326 of the Indian Constitution. However, going by the answers of UPSC, the correct answer here was constitutional right, as it has been provided under Article 326 of the Indian Constitution. So in this news, you need to know about Article 326 of the Indian Constitution, the fact that right to age was reduced from 21 years to 18 years through Constitution's 61st Amendment, and the fact that under Section 62 of Representation of People Act, prisoners, under trial prisoners, and those people who are in police custody does not have right to vote. And even the Constitution of India under Article 326 disqualifies a person to vote on grounds of non-residence, unsoundness of mind, crime or corrupt or illegal practice shall also be disqualified. So this topic becomes very important both from your prelims and mains perspective, and in your mains this topic gets covered under important features of Indian Constitution and also amendments, that is the Constitution 61st Amendment, and salient features of Representation of People's Act both 1950 and 1951. So on this note, let's go through their important provisions. Now regarding the RPA 1950, it provides for allocation of seats in House of People under its first schedule. It provides for filling of seats in House of People and parliamentary constituencies through direct elections. It provides for total number of seats in legislative assemblies and assembly constituencies in its second schedule, qualification of voters, preparation of electoral rolls for parliamentary, assembly and council constituencies. It provides for delimitation of constituencies. It provides for power of Election Commission to maintain delimitation order up to date. It provides for allocation of seats in the legislative councils under the third schedule. It provides for delimitation of council constituencies and also constitution of electoral colleges for the filling of seats in Council of States allotted to Union territories. Now regarding Representation of People Act 1951, it provides for actual conduct of elections by Election Commission, administrative machinery for conducting elections, election expenses, election disputes, by-election, registration of political parties. But please remember, deregistration of political party has not been provided. So Election Commission does not have power with respect to deregistration of political parties. Further, it provides for qualification of members of parliament and state legislatures, disqualification for membership of parliament and state legislatures, notification for general election, and corrupt practice and electoral offences. So please remember these important provisions with respect to RPA 1950 and RPA 1951. Thus, this article becomes important both from the perspective of prelims and mains examination. With this, let's take up the next news for discussion. Now, the next news to be taken up appears on page number 4. Now, this news mentions Soren seeks time to appear before Election Commission. An Election Commission has asked the Jharkhand Chief Minister to appear before it in violation of Section 9A of Representation of People Act of 1951. Now, Section 9A of Representation of People Act of 1951 comes under Chapter 3 of RPA. Now, it's important to understand as Chapter 3 provides for disqualification for membership of Parliament and state legislatures. So basically, any MP or MLA shall be disqualified under the following sections, and Section 9A provides for disqualification for government contract. So it means that the MP or MLA must disclose this particular information in their filing of nomination. So Section 9A of RPA 1951 mentions about disqualification for MP or MLA for government contracts. Here it says that a person shall be disqualified if and for so long as there subsists a contract entered into him, that is by the MP or MLA, in the course of his trade or business with the appropriate government. Now, according to Section 7A of Representation of People Act, appropriate government means in relation to a member of parliament, the central government, and in relation to a MLA or a member of legislative council, then the state government. So this provision highlights that appropriate government means in relation to any disqualification for being chosen or for being a member of either house of parliament, then it means the central government, and in relation to any disqualification for being chosen as or for being a member of legislative assembly or legislative council of a state, then the state government. So the three grounds with respect to disqualification under Section 9A includes: contract should be subsisting on the date of scrutiny of nomination. Second, contract should be either for supply of goods to the government or for execution of works. And third, contract should be with appropriate government. So appropriate government means in case of members of parliament, the central government, and for MLAs and MLCs, the state government. So this provision says that a person shall be disqualified if there subsists a contract entered into him in the course of his trade or business with the appropriate government for supply of goods or for execution of any works undertaken by that government. So from your examination perspective, you need to know about section 9A, which provides one of the grounds of disqualification for an MP or an MLA in case there subsists a government contract on the day of scrutiny of nomination. Now chapter 3 of RPA provides for disqualification of memberships of parliament and state legislatures on various grounds. So on this note, let's go through these different disqualification which has been provided under RPA 1951. So here section 8 mentions about disqualification for various criminal offences, and such person shall be disqualified where the convicted person is sentenced to only fine then for a period of 6 years from the date of conviction, and if a person is sentenced to imprisonment from the date of such conviction and shall continue to be disqualified for a further period of 6 years since his release. Now section 8A of RPA 1951 provides for disqualification on grounds of corrupt practices. So question of disqualification to be submitted to the President. Period of disqualification shall not exceed 6 years, and before giving any opinion, President shall take the opinion of Election Commission and act accordingly. Now section 9 provides for disqualification for dismissal for corruption or disloyalty. So it says that a person having held an office under the government of India or under the government of any state has been dismissed for corruption or for disloyalty to the state shall be disqualified for a period of 5 years from the date of such dismissal. And a candidate dismissed from the government service within the last 5 years must produce a certificate from Election Commission that he was not dismissed for corruption or disloyalty if such person intend to stand for election. And such certificate obtained from Election Commission must be filed along with their nomination papers. Now section 9A we have just seen, disqualification for government contracts. Section 10 provides for disqualification for office under government company. So it says a person shall be disqualified if he is a managing agent, manager or secretary of any company or corporation other than a cooperative society in the capital of which the appropriate government has not less than 25% of share. So such person shall also be disqualified. And further, section 10A provides for disqualification for failure to lodge account of election expenses. So if the Election Commission is satisfied that a person has failed to lodge election account or account of election expenses within the time and the manner required under RPA and has no good reason or justification for such failure, that is the person has failed to provide election expenses and there is no proper reasons for such failure, then Election Commission can declare such person to be disqualified, and such person shall be disqualified for a period of 3 years from the date of such order of the Election Commission. Thus, these are some of the important grounds for disqualification provided under Chapter 3 of Representation of People Act of 1951. And all these grounds becomes important both from your prelims and mains point of view. And regarding your syllabus, this topic gets covered under GS Paper 2, especially with respect to salient features of Representation of People Act of 1951. Now, based on our discussions so far, these becomes your practice question for your prelims examination. So the first question is, according to the Constitution of India and based on Constitution 61st Amendment, a person shall not be allowed to vote if he or she is first, not a citizen of India, second, less than 21 years of age, third, of unsound mind, and fourth, involved in corrupt practice. So the question is, which of the statements given above are correct? Options are A, 2, 3 and 4 only, B, 1, 2 and 4 only, C, 1, 3 and 4 only, and D, 1, 2, 3 and 4. Now coming to the second practice question, it says, Representation of People Act 1950 provides for which of the following provisions? Options are, first, allocation of seats in Lok Sabha, second, preparation of electoral rules for parliamentary, assembly and council constituencies, third, delimitation of constituencies, and fourth, allocation of seats in the legislative council. So again, the question is, select the correct answer using the code given below. Options are A, 2, 3 and 4 only, B, 1, 2 and 4 only, C, 1, 3 and 4 only, and D, 1, 2, 3 and 4. Now based on our discussion so far, I hope you will be able to solve these two practice questions. Now let's take up this practice question number 3. It says, Representation of People Act 1951 provides for disqualification for membership of parliament and state legislatures on which of the following grounds? Options are: first, corrupt practices; second, continuation of government contracts even after becoming MP or MLA; and third, failure to lodge election expense. Question is, select the correct answer using the code given below. Options are A, 1 and 2 only; B, 2 and 3 only; C, 1 and 3 only; and D, 1, 2 and 3. Now this question was also asked in the UPSC prelims examination for the year 2020. So this also becomes your fourth practice question. It says, consider the following statements. First, according to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature of that state. Second, according to RPA 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. The question here was, which of the statements given above are correct? Options were A, 1 only; B, 2 only; C, both 1 and 2; and D, neither 1 nor 2. So try to solve these practice questions as it will help you in understanding the topics. With this, let us move forward with our further discussions. The next news to be taken up appears on page number 12. Now this news says, new norms for sentence remission. Ministry of Home Affairs issues rules on release of prisoners to mark 75th year of independence as a part of Azadi Ka Amrit Mahotsav. So according to the new directions issued by Union Ministry of Home Affairs, it intends to allow special remission to prisoners based on certain criteria, and in this direction has asked the state governments and union territories to form state-level screening committee which shall comprise of Home Secretary, Law Secretary, Director or Inspector General of Prisons to examine cases of eligible persons who can be released through this special remission. Now, remission refers to reduction in duration of sentence without changing the nature of imprisonment. So effectively, remission, that is reduction in the duration of sentence, effectively results in release of the prisoner. So this special remission activity, which is a part of Azadi Ka Amrit Mahotsav, will be done in 3 phases. So in the first phase, group of prisoners will be released on 15th August 2022, followed by the second phase, that is 26 January 2023, where again number of prisoners will be released, followed by 15th August 2023. And accordingly, the Union Ministry of Home Affairs has asked state governments and union territories to form state-level screening committees, which will then decide which people can be released. Now, the rules of Ministry of Home Affairs has highlighted various categories of prisoners which can be considered by the Select Committee of State and Union Territories for release through special remission. So it includes such categories of prisoners who have consistently maintained overall good conduct, especially those with no punishment during convict period in the last 3 years may be eligible for special remission. Now, the categories of prisoners who is eligible for this special remission includes women convicts of 50 years of age and above who have completed 50% of their total sentence period. However, this period will not count the period of general remission which they have earned. Now, transgender convicts shall also be considered of 50 years of age and above who have completed 50% of their total sentence period, again, but without counting the period of general remission which have been earned by these transgender convicts. Now, male convicts will also be considered who are 60 years of age and above who have completed 50% of their total sentence period, again without counting the period of general remission earned. Now, other categories of prisoners who will be considered by the screening committee includes physically challenged or disabled convicts with 70% disability or more and who have completed again 50% of their total sentence period. Now, their disability must have been certified by a medical board. Further, it shall also be applicable to terminally ill convicts. Now, this shall also be certified by the medical board. Such convicted persons who have completed 2/3, that is 66% of their total sentence period, but again not counting the period of remission. Further, these rules shall also apply to such poor or indigent prisoners who have completed their sentence but are still in jail due to non-payment of fine imposed on them by waiving of their fine. And lastly, persons who committed an offence at a young age, that is between 18 to 21 years of age, and they had no other criminal involvement or case against them, and these people who have completed 50% of their sentence period. So these are the broad categories of people which shall be considered by the state level screening committee to be released through special remission. Now, the rules issued by Union Ministry of Home Affairs also highlight that special remission shall not be applicable or granted to the following categories of convicts. These includes persons convicted with death sentence or where death sentence has been commuted to life imprisonment, or persons convicted for an offence for which punishment of death has been specified as one of the punishment. Thus, those convicts who have been awarded death sentence shall not be considered for the case of special remission, and also such convicts whose death sentence has been commuted to life imprisonment. So here we must also understand commutation. Now, commutation means changing the punishment from one category to another. For example, changing the death sentence to life imprisonment. So such convicts whose death sentence has been converted or changed to life imprisonment shall not be considered for the case of special remission. Now, other categories of convicts who shall not be considered for this case of special remission as a part of Azadi Ka Amrit Mahotsav are those persons convicted with sentence of life imprisonment, convicts involved in terrorist activities, or persons convicted under TADA, that is Terrorist and Disruptive Activities, Prevention of Terrorism Act, POTA, UAPA, Unlawful Activities Prevention Act, the Explosive Substances Act, National Security Act, Official Secrets Act, Anti-Hijacking Act 2016. Further, also those prisoners convicted for dowry death, prisoners convicted for counterfeiting currency notes (FICN), which we had already discussed with respect to cases registered under section 489A to E of IPC, prisoners convicted for offence of rape, human trafficking, and offences under the POXCO Act, along with Immoral Traffic Prevention Act of 1956. Further, those prisoners convicted under Prevention of Money Laundering Act, Foreign Exchange Management Act, Black Money, Undisclosed Foreign Income Assets and Imposition of Tax Act, prisoners convicted under NDPS Act, prisoners convicted under Weapons of Mass Destruction and their Delivery System Prohibition of Unlawful Activities Act, prisoners convicted under the Prevention of Corruption Act, prisoners convicted for offence against the state, that is under Chapter 6 of IPC, or any other prisoners convicted under any law which according to the state governments or union territory government should be excluded, or such prisoners should not be considered for special remission. So these are the categories of convicts which shall not be considered for the case of special remission as a part of Azadi Ka Amrit Mahotsav. So according to the direction of Ministry of Home Affairs, the state level screening committee shall further review the records of all prisoners and identify eligible convicts or eligible prisoners who can be released. And this decision of the state level screening committee shall be forwarded to the state government. So on receiving the recommendations of the screening committee, the state government will examine the recommendations thoroughly while ensuring that hardened criminals, repeat offenders, and those convicts under the prohibited categories are not considered for special remission. Now, the state government does not want to consider these convicts, namely hardened criminals, repeat offenders, or convicts under prohibited categories, with a view to ensure public peace and well-being of the society. So, once state government has reviewed the names provided by select committee, then after such review, it will place the names of such convicts who are to be released through this special remission to the governor under Article 161 of the Indian Constitution, which empowers the governor to release such convict through remission. Now, in such cases where approval of the central government would be needed, as per law, such names would be sent to the Ministry of Home Affairs for seeking its concurrence and approval. Now, this would be because it is possible that CBI or other investigative agencies of the central government might be investigating any case with respect to that particular convict. So, in such instances, approval of the central government, particularly the Ministry of Home Affairs, would be required. Now, if a foreign national convict is to be released through the special remission, then consent of Ministry of External Affairs would also be required. So it says that the foreign national convict shall be released only with specific consent of Ministry of External Affairs, and cases of foreign nationals are to be sent to the Ministry of Home Affairs sufficiently in advance before submitting the recommendations to the governor for obtaining consent or clearance of the Ministry of External Affairs. Now, the rules of MHA, that is Ministry of Home Affairs, also provides for the aspect of counseling sessions for such convicts who are to be released. So it says that prior to the release of prisoners, counseling sessions may be held for the prisoner and their family members to facilitate their rehabilitation back in the society. And in such sessions, these convicts will be sensitized and encouraged with respect to their contribution to the society after their release. So these are some of the important highlights of the guidelines issued by Ministry of Home Affairs with respect to special remission, which has been conceptualized as a part of Azadi Ka Amrit Mahotsav, whereby a category of convicts shall be released in 3 phases. Thus, this topic becomes important both from our prelims and mains perspective, specifically under governance and the aspect of social justice, and under GS paper 2, specifically with respect to welfare schemes for vulnerable sections of the population by center, and also as a part of prison reforms. So after understanding this particular topic, let's take up the next article for discussion. The next news to be taken up appears as a lead article on page number 6. Now this news says, tackling the crisis of rising global food prices. Analysis shows factors outside agriculture to be responsible with lessons for the world and in food system management. So this article highlights that the food crisis which has been happening, and here food crisis refers to steep increase in price of food across the world and also supply disruptions caused due to various reasons outside agriculture. So the author highlights that food crisis across the world has been happening at shorter intervals, and the interval highlighted in this article are 1973 to 76. The second food crisis occurred between 2007 to 2012, and this one started at the fag end of 2020 and is still continuing. So this article highlights that the reason for food crisis is mainly triggered outside agricultural reasons. So the current reason includes COVID-19 and also Ukraine-Russia war. And another aspect of food crisis in the present circumstances is that this food crisis has not caused because of any shortfall in production, rather for factors which are outside agricultural issues. And the article also says that not even the interval between the food crisis is reducing, but also the intensity of food crisis is further intensifying or increasing. Now, the reasons highlighted in this article with respect to the present food crisis, which started in the late 2020, is mainly due to supply chain disruption due to COVID-19. Now, this impacted global supply chain, and this disruption in supply chain has further been intensified with the ongoing Ukraine-Russia war. Now, another very important reason highlighted in this article is regarding diversion of food for biofuel needs. And this is happening also to sustain renewable energy. Now, another reason for food crisis is increase in price of fertilizer and other chemicals used in agriculture, as the price of fertilizer has increased by 150% in the international market. So all these reasons has been highlighted in this article with respect to the current or ongoing food crisis. Further, this article also highlights about the increase or rise in food prices for vegetable oils and also for cereals. Now, regarding vegetable oils, 38% of the vegetable oil produced globally is traded across the world. And with respect to wheat, 25% of the wheat produced is also globally traded. So, greater the percentage of global trading of any commodity, the greater is the risk when supply chain disruption impacts. So as of now, we are seeing or we are witnessing a steep increase in the price of vegetable oils and also increase in the price of wheat in the global market. Further, 10% of rice is globally traded and 16% of corn is globally traded. So any food crop or cereal which has a higher percentage of global trade, then such food crop or cereal will get impacted on a larger scale and their price will increase on a sharper note if there is a supply chain disruption. Now, another reason highlighted in this article is that a part of food crop is used for biodiesel. And here the author says that with respect to vegetable oil, 1% of vegetable oil was used for biodiesel in 2003, and this has increased to 15% in 2021. So there is a large scale of diversion of food crop or food cereals which is consumed by humans for biodiesel or for renewable energy purposes. So this demand of increased share of renewable energy is further intensifying food crisis globally. Now even India is impacted by the food crisis, and in this backdrop the government of India has taken number of steps including maintaining buffer stock for various cereals. Government of India has banned export of wheat and has also placed restrictions on export of other food commodities. Now, because of the global supply chain disruption, international market was looking for 50 million tons of wheat to compensate its loss due to Ukraine war. Now, seeing the global situation and also to ensure that India domestically does not suffer any wheat shortage, the government of India banned the export of wheat. Thus, the government of India took this step to ensure food security in India and also to ensure that there is no scarcity of food in the country. Thus, to tackle the global food crisis, the article suggests certain steps which needs to be taken. So the article highlights about green revolution technology which needs large-scale global adoption. Further, there is a need for increased spending on agricultural research and development, especially by public sector, and also multilateral development agencies such as World Bank, Asian Development Bank, International Fund for Agricultural Development, etc. Further, there is a need to strengthen global agricultural research system under Consultative Group on International Agricultural Research, that is CGIAR. Further, there is a need to calibrate diversion of food crop for biofuels so that we can understand the implications of food security when part of food cereals are diverted for biofuels. Further, the article suggests that the factor of climate change as a reason for future supply shock needs to be understood and also managed globally. And in these backdrop, there is a need for a global buffer stock in order to cater to any future crisis impacting food security. So these are some of the suggestive steps which needs to be undertaken at a global level. Thus, this article becomes important mainly from the perspective of mains examination, as questions can be asked with respect to steps which needs to be taken at a global scale to address the issue of food crisis. And from our mains perspective, this topic gets covered under GS paper 3. The next news to be taken up also appears on page number 12. Now this news says Center to boost supply of fortified rice. Food Secretary says that the nutritional benefits of fortified rice in consuming the grain far outweighs any risk. So according to this news, the Union Food and Public Distribution Secretary has stated that the center has started the second phase of distribution of fortified rice from 1st April, and a total of 90 districts have been covered, and the center is targeting 291 districts. So, the Cabinet Committee on Economic Affairs chaired by the Prime Minister has accorded its approval for supply of fortified rice throughout the targeted public distribution system under the National Food Security Act, Integrated Child Development Services, Pradhan Mantri Poshan Shakti Nirman, that is PM Poshan, which was the erstwhile midday meal scheme, and other welfare schemes of the Government of India in all states and union territories by 2024 in a phased manner. And this present news highlights about phase 2, which is phase 1 plus TPDS, that is Targeted Public Distribution System, and OWS, which is other welfare schemes in all aspirational and high burden districts on stunting, which is a total of 291 districts. So all these districts will be supplied fortified rice by March 2023. Phase 1 covered ICDS, that is Integrated Child Development Scheme, and PM Poshan in India all over by March 2022. And phase 3 includes phase 2 plus covering the remaining districts of the country by March 2024. So here we need to understand what is rice fortification. Now rice fortification means increasing the micronutrients of rice, and according to the Food Safety and Standard Authority of India, it defines fortification as deliberately increasing the content of essential micronutrients in a food so as to improve the nutritional quality of food and also to provide public health benefits with minimal risk to health. So as you can see that in the second phase, it covers total of 291 districts and also high burden districts on stunting. So fortified rice will help to reduce stunting among children. Now stunting refers to impaired growth and development that children experience from poor nutrition, repeated infection and inadequate psychosocial stimulation. And as you can see in this picture, child stunting refers to low height for their age, whereas child wasting is low weight for height, and child overweight is high weight for height. Now, rice fortification is done by adding vitamins and minerals, namely iron, folic acid, and vitamin B12 after its harvest. And according to FSSAI norm, 1 kg of fortified rice will contain the following: 28 to 42.5 mg of iron, 75 to 125 microgram of folic acid, 0.75 to 1.25 microgram of vitamin B12, and these fortified rice may also contain zinc, vitamin A, vitamin B1, vitamin B2, vitamin B3, and even vitamin B6. So from your prelims perspective, you need to know the important micronutrients which are added in rice fortification. Now, based on our discussion so far, this becomes your practice question for the day. In rice fortification, which of the following vitamins or minerals are added? Options are: first, iron; second, folic acid; third, zinc; fourth, vitamin B12; and fifth, sodium. Question is, select the correct answer using the code given below. Options are: A, 2, 3, 4 and 5 only; B, 1, 3, 4 and 5 only; C, 1, 2, 3 and 4 only; and D, 1, 2, 3 and 5 only. Now coming to the answer of yesterday, the question was, consider the following statements. First, all forms of child labor in India is banned for children under the age of 14. No, this is incorrect. Second, children between the age of 14 to 18 cannot work in hazardous industries for more than 4 hours each day. No, this statement is also incorrect. So the question was, which of the statements given above are correct? Hence the correct answer becomes D, that is neither 1 nor 2. With this, we come to an end to today's discussion. Thank you for watching DNS.